I'll also start by acknowledging the traditional owners of the land on which we meet today and paying my respects to elders past, present and emerging. I also just want to acknowledge the preparation time we've had for this presentation, but I think it's interesting to reflect on in that the questions we're being asked to grapple with are privacy and consent, and given that everyone in the room is grappling with that, I would imagine almost daily, regularly, we don't have a lot of time to prepare to ask and answer the questions that we need to deal with these issues. And I just want to get a bit of a show in the room before we start about how many people in the room are managing staff and taking a management approach. So we've got a show of hands, I'd say about a quarter of the room. The rest of you, are you frontline caseworkers who are dealing and grappling with this? What's the sort of background of other people in the room?
Maybe the policy officers.
Policy. So you'd be developing organisational policies. Yeah. Practice people who translate policy into practice. Yeah. Okay, so I'm just getting a bit of a show of the room. One of the things I think in reflecting on preparing this presentation is I'm a manager of staff, and many people will say to you, 70 to 80% of your time as a manager is spent managing people. And sometimes that feels, I think, a little bit difficult when you're doing that on a day-to-day basis because you're trying to do the core business as well as managing the people who are delivering the core business. But the more I work in this sector, the more I come to realise handling information and the information we share between us about our clients is actually a really core part of our business, and it's actually a really complicated part of our business. There's no easy answers to it. So just to talk a little bit about my professional background, I've worked for about 21 years as a lawyer in the community sector, mainly with children and young people, but since starting at the Office of the Public Guardian, I've got more of an appreciation for adults with impairments because we're appointed as guardians for people who have impairments, a range of different impairments, ABI, mental health combined with intellectual impairment. And Mel, you might want to introduce about your background.
I've been essentially a government lawyer for the last 11 or 10 years. I've got a history in prosecution work and working on projects with the Queensland Police Service for vulnerable clients or users of the Queensland Police Service, and then transitioned to the Office of the Public Guardian about 3 years ago, and I've worked as a child advocate and in the children and young people team for about 3 years.
And I think something to reflect on as a lawyer is a lot of our business is about reviewing documents, records, materials as we build the picture of our clients. It's a little bit different, although similar to the work of community sector workers, whether you be a social worker or a youth worker, whether you work in the policy or practice background, which is about how do we implement or deliver a service to a group who we're contracted to provide a service for, in whatever funding environment you're operating in. So we obviously have obligations to the clients that we're delivering these services to, and that's something we grapple with as a statutory authority when our statutory purpose is the promotion and the protection of the rights and interests of children and young people who are in visitable sites. It's a technical definition, but children and young people in the care system, basically, child protection system across the whole continuum from intervention with parental agreement for people who are familiar with that term, pre-court assessment processes, right through to a long-term guardianship for a child who's on long-term guardianship to the chief executive. And then also we have this function where we are appointed as legal decision makers for people who have impairments. And I have to say, having come into this that area later in my career, it's an area not well understood across the board by many service deliverers. So we'll talk a little bit about that. So in terms of rights and scene setting for privacy and consent, I guess we're all familiar, depending on our area of practice, on the UN conventions and how the UN conventions set a tone. So many of you have worked in the sector for a long time, and you know the tone of those, the two main conventions I'm just sort of reference briefly is obviously the Convention on the Rights of the Child and the Convention for People with Disabilities. But really what those conventions are about is about setting a standard around respect and how how children and young people or how people with disabilities will be treated with respect at a sort of UN convention international perspective. And then obviously the Commonwealth law and the state law refers to those UN conventions sometimes when it establishes principles and legislation to say this is how this legislation is going to be implemented. So in Queensland, to just use a quick example, we've obviously got the Child Protection Act, and the Child Protection Act has principles setting out in sections 5A to I think there's now to E. That's sort of the principles which very much reference the convention about how you make decisions under that act. We similarly have principles within our act about how we're meant to do our job, and you'll find if you ever, and unfortunately as lawyers we often have to do this, look at a number of different pieces of legislation, they often set the tone by saying, here's the purpose of why we've created this act, and here's the principles in which how we administer this act. But what you'll find in practice is that sometimes gets a bit lost. And I mean, one area I think you'd probably be all familiar about, and we're going to hear about more today, is the right to information. So what is that process about? And so I just wanted to set the scene with that rights framework and talk about that as a setting. And then go to, if I can. So obviously there's been a previous workshop and there's been previous presenters. Some of you have been to that workshop, which I understand was about a year ago. Everyone's here for a refresher. And I guess the complexity of this is that the answer is not simple. And so all of your organisations would most likely have policies and guidelines for how you do business. And some of those policies and guidelines will touch on the issues of mandatory reporting, if you have any requirements under your funding agreements or legislative requirements. They'll touch on privacy and how you keep the information that's relevant to your clients and how you might share that between yourself and perhaps child safety, if you're a service that's contracted to provide some work for them, or when you're asked for information from other agencies or, for example, from the police, where they might be investigating, or as we get more and more complex, litigation where people are in the legal situation subpoenaing information and asking you to provide files. So that's the sort of service complexity I hope I'm sort of recounting that you're dealing with. And so then going to the legislative setting around that, which we'll hear a bit more about as we progress over the course of the day, we're talking, do you want to set the scene with those two?
So Catherine was speaking about the United Nations Convention. So they really set the scene for us as a nation, but they don't set the laws for us. So whilst we're member states to the United Nations and we sign up as signatories to these conventions, they don't really impact our day-to-day laws unless they're enacted in our either Commonwealth or state legislation. And so Australia has done that with the United Nations Convention on the Rights of the Child and People with Disabilities. So that's enacted in the Commonwealth state in the Privacy Act in 1998. And that will apply to your community organisation, for example, if you have a turnover of more than $3 million a year, or you're a health service provider. And you'll know for your organisation if that applies to you. And in a state basis, it's the Information Privacy Act, which I'm sure some of you will have all heard about in your day-to-day work. And so that sets out for our state the information privacy principles, and that'll apply to your organisation if you have a contract with the Queensland Government which requires you to comply with the information privacy principles, which if you're dealing with child safety or disability services, you're very likely to have. So that requires you to comply with those principles. So really what that boils down to, and this isn't legal advice, it's just some legal information, is about how do you deal with a person's private and personal information. And so that's defined both on a Commonwealth basis and on a state basis. They're very similar definitions, but your personal information is, and it's not just information as in what's their age, date of birth, it's our opinion. So if your staff are forming an opinion about how to treat somebody or what is the next step in their in how you're going to manage their situation, your opinion is their personal information. So it's a really important feature to note about personal information. It also includes whether or not your opinion is true or not, and whether or not that opinion has been recorded in material form or not. So you've got to be really careful, and it's a real complexity to your work when a staff member is forming an opinion about how to do something and that doesn't always get articulated in written form. That's still that person's personal information. We have to grapple with how do we manage that. You go.
So one of the questions I guess we asked for ourselves is, can I share, if we're dealing with this issue around the personal information we're collecting as an agency, when can I share it? And I think for us, we have grappled with this issue as an agency ourselves. We've grappled with it in two ways. One, in terms of how the different functions within our agency work and seeing that we're performing different roles, so can we share that information between us when we're working with clients? So I'll give you one example of that. If we are performing a visiting function where we're visiting children and young people in care, and they can be aged from 0 to ageing out at the age of 17, we might come across children and young people with disabilities where there have been assessments about their capacity and access to services. One of those young people might require the advanced appointment of a guardian as part of their transition to independence planning, and so they require an application to be made to QCAT to see whether we should be appointed as their guardian. And then when they transition through, we could be appointed as their guardian and then have to make decisions about them in terms of their care experience, their disability, and for us it's often around accommodation and service provision when they go into be a user of disability services as an adult. So in that example, we are performing different functions, and each of those functions is gathering information about that client. I'd imagine in your services, some of them are large services that are divided across funding streams. They might be providing different services, a family support intervention service, a counselling service, and there'll be times when you might be grappling with how those different areas share information. Often very appropriate to do because we're trying to deliver a service that's holistic and actually respectful and delivers to the need of the client. But sometimes one part of our agency might get information about the client where we've got to think about, well, can we share and should we share that with another part of the agency? So for us, when we're making decisions about adults with impairments, a lot of those adults with impairments live in sites, visitable sites that our adult visiting program goes and visits. So I'd imagine that complexity, and correct me if I'm wrong, would be similar to some of your agencies where you're offering different programs, different funding streams. Some of them are Commonwealth, some of them are state. And so you might, on occasion, have case meetings where you're coming together as workers and discussing clients and sharing information about how to service provide to them. So I think one of the questions I imagine, or one of the things that you would do in setting up your service, which we try to do, is be really clear about what is my role and what am I doing when I'm engaging with the client, and how do I explain that to the client. So your policies and your practices would set that framework for your workers, and often for you as managers when you're supervising your workers, it would be about re-establishing and clearly establishing the parameters of why am I working with this client and what am I doing with them. When you're working with children and young people and adults with impairments, and there's probably people in the room who've been doing that for a very long period of time, you would well appreciate that that conversation is a continuous conversation. The issue of privacy and confidentiality is often not something you can reconcile by having a conversation at the outset to say, we're going to share information and you need to know that, because it's not something they'll necessarily recall. Many of you where you've had referrals, if it's from a statutory child protection system, or it might be some sort of mandatory referral through a domestic and family violence intervention, it's also a mandatory referral. It's a coercive referral in the sense that they have to be there. So if they're in that position, it's, I think, really important to set the parameters of what your role is and what your intervention is, and that you have clear and consistent messaging in your policies and your practices, but also for managers in the supervision you do with staff about how do we message manage this for the client. So one of the consistent conversations I have, and really Melissa is the one delivering the supervision to the ground workers, is this conversation doesn't happen once. It happens consistently when you are working with clients, and many of you have done this for a very long time will know that. I think some of the other key messages that need to be shared with our client groups are that we talk to each other and we share information, and to be transparent and open about why and when we would do that. So many of you will have been in a position at some point in your service delivery where you've become privy to information that you're concerned about and worried about, and you're worried about whether or not you should share that with someone else because it might lead to someone getting hurt or the client in fact hurting themselves. So that's when we have to ask those questions, is this information that means I have to share this with someone else, and what should I do about that? So I think your funding arrangements and your contractual obligations as service providers will link to certain responsibilities under the privacy legislation that you need to be aware of. Your agency policies and practice will set guidelines for you in terms of how you go about your business, And they, as you all know, particularly the poor people that have to write them, are living documents. So they will have to be reviewed, and you may have a case that comes up that doesn't fit the mould. It's something that comes out of left field and you didn't see it coming. But that's a really good opportunity to revisit your policies and practices and say, do they fit the bill, or do we need to review them? You've got obviously then your professional supervision, and I have to say I think this is one thing as lawyers we could learn a lot from the social work practice about structured supervision and those opportunities that might present themselves in your case discussions and also in your individual one-on-one supervisions, where you revisit that with staff. And I don't want to overcomplicate the issue of record keeping, because I actually think it should be simple. Your records don't have to be voluminous, but they should be concise and they should be clear about what you did. So you may not have the luxury of sitting down, nor may it be appropriate given the level of capacity that you've got with the client, to sit down and go through a painstaking, laborious process to ensure they understand, you know, every aspect of what you're doing, because you might have to do that in a staged process depending on your intervention. A lot of you won't have the technology luxury of sitting down with a laptop and being able to write up something and then sign them up to a piece of paper. But taking good records and keeping good notes, and many professionals in this sector are really good at this because we review them. But they don't have to be long and voluminous, they just have to be clear. I had a discussion with the client around the issues of privacy. I explained these aspects of it, and they indicated this to me, and so I'm clear that at this point they understood what we were doing and that they provided consent. But when we're dealing with children and young people, and when we're dealing with adults with impairments, you will know from your own direct casework experience, it's not a simple thing to determine whether or not capacity is understood. People understand what's going on, in the sense that the nature of the decision affects their ability to understand how stressed they are. So we talked about that sort of mandatory referral. They're there because they don't want to be, they know they have to be, and that will impact on your intervention with them. And also it's about what they're being asked to do at a particular period of time. Many of you would have seen that clients will come to you and they'll have a hierarchy of priorities, and sitting down and working out through a consent process is not going to be high on that list of priorities. So there's no ideal environment. It just has to be created by you as professionals, and many people are very good at doing this. And unfortunately, the concept has to be revisited, not just in the repetition around explanation, but also for children and young people and adults with impairments, and frankly anyone, what you're experiencing in terms of context impacts on your ability to understand and consent. So if I'm a highly stressed mother in a hospital setting that's being asked to consent to life-threatening emergency treatment for my child, my ability to take in complex medical information is going to be impaired. So where we're working with this sort of client group, and many of you are very experienced in doing so, you know that you're providing what we would call the scaffolding to help them understand what they need to ask questions about, and you might have to revisit concepts with them. And it's fine not to get things. I think this is an issue for me in terms of the sector and client groups. For children and young people and for adults with impairments, it's actually really fine and okay for them not to understand something first up, because I don't know about how many of you have tried to access technical advice about your finances or your medical situation and you haven't understood it the first time, or you might access a professional who explains it really well, and then you might go into a professional who doesn't explain it well at all. So I think it's also not a test that we win or lose by demonstrating whether or not we understand. So we've got 15 minutes left, and in terms of the presentation, we've talked about the complexity of the client group, we've talked about your organisational setting, we've talked about the concepts of privacy and consent, which, passing over to Lem, I think he'll provide you with more technical. I've read Lem's previous explanation of privacy, and I think he'll give you that nice technical overlay about the privacy principles. But one thing to keep in mind too is that the privacy principles are also a bit like a guideline about how do you respect the information and how do you manage it respectfully and how do you release it respectfully, but that there will be local laws that override that where appropriate, and the Child Protection Act being one good example of that. We've talked also about the concepts of consent, and I guess the 4 elements of that being voluntary, informed, current and specific, and the issue of capacity. So GILIC competence for me is really like supported decision making for people with disabilities. It's a direct and constant engagement. It kind of never ends. And for all of you who work with people with mental health issues or people who are using drugs and alcohol, you'll know too that those will impact on their ability to understand at particular points in time. And many of you are very experienced in being aware of when a person presents to you and they're clearly under the influence, or you're concerned about their ability to take information and understand. In terms of what do you do when you've got a concern, obviously you use your professional skills, you talk to your supervisor, you look at your organisational policies, and you workshop what your plan is and how to manage this concern. Lawyers don't have magical answers about this. We go through the same process that you do. We refer to the Act. I guess that's a skill set that we have that you'd say you struggle with. That's fair enough. But please be clear too, we also struggle with the application of legislation in terms of practical situations. So you're not alone in having to work out those complexities. In terms of where there is a guardian appointed, and there will be examples where you will come across people that have appointed guardians, it would be wise to get in touch with them and to talk to them about what decisions you're making or what you'd like them to be involved in, and explain that to them. They may not be able to say, this is what you should do, but they may be able to confirm for you, yep, that's a decision I'd really like to know about, or I'd like to be part of your decision making about that. I think many of you are probably familiar with the concept of GILIC competence. And again, one of the things I'd say about, for people who work in the community sector, and many of you do for a long period of time, you're actually quite experienced at working with marginalised client groups. It's really hard, as you would appreciate, when marginalised client groups come against large service providers like banks, health professionals, educational settings. Sometimes they get a person who's really experienced with working with people like them, and so they're actually really clear about the concerns you might have around consent, and they'll work with you around that. But part of what we do in this sector is we're actually a bridge for clients when they're trying to access big systems, and so you will on occasion be called in to work with other professionals who don't really understand the concepts of engagement the way you do, and that'll be part of your role. There's obviously other tools we can use. The use of interpreters is a really important thing that we have to use in relation to people who speak English as a second language. But I also think, and you will all know this, people that people feel comfortable with and how we manage support people around children and young people and adults. Many of you will have experience of working with really good support people who will make people feel comfortable, who will set the tone of your interview and be supportive in terms of you and performing your role. And many of you will have had experience of support people who have agendas of their own in relation to that person, but also perhaps in relation to your service or in relation to the statutory child protection system, for example. And they present a challenge that has to be managed, because when you're managing someone's privacy and their consent, you have to think about, who am I engaging with? Who is my client, effectively? Because particularly for children and young people, there will be a lot of people around them who will have a view, but the same is said of adults with impairments as well, who'll have a view about what should and shouldn't happen. So the question for you is, what's my role and what information should I share with them? Just because they ask me for it doesn't necessarily mean I have to give it, which is not an easy question sometimes to ask and answer. And the issue of capacity, there is a good guide or a legal tool that we'll make a reference to, which is produced by Queensland Advocacy Inc. And the other reference I just wanted to make before throwing to questions, we've probably got about 5 minutes, is if you haven't already, I am a big fan of the Dovetail Good Practice Guides, which are available on Dovetail's website. There's one in particular called Legal and Ethical Frameworks. And I think at around page 19, 20, 21, there's a bit of a guide about how do I grapple with making decisions that are difficult. And I think that overlay or that framework would fit really nicely for your decision making around privacy and consent. You'll have some technical aspects you've got to fill in there, but that's been developed by dovetailing consultation with QUT Academic, and also many of you will be familiar with Youth Advocacy Centre. They're laying down the law series, deals with this a little bit, and that's where that framework came from. I'd really recommend you have a look at it. It doesn't provide you the solution, but what I find really helpful about it is it asks you a lot of questions and challenges you with a lot of prompt questions, which I think gives you a really good framework, like, what does the law say? What does my organisational policy and procedures say? What's my professional practice say? So as lawyers, for example, we have ethical responsibilities around our client relationship. And as social workers, for example, if you're trained, you might have some ethical responsibility as health professionals. And then it goes through a process of how do I solve this problem? Because really, bottom line, on a day-to-day practice, it's about problem solving. How do I deal with this problem of privacy and consent, and how do I solve the problem that's been presented to me? And I think many of you would be doing this very well all the time, and then you'll be having times and moments where you feel challenged and you don't have the skills or the tools you need. Questions? So the question, I think, for the benefit of the recording was about observations around working with people with impairments where there is a guardian appointed, and some complications around you having organisational processes that may mean you need forms signed or things progressed, and then interacting with a guardian who's appointed, and they may have a different understanding of what the expectations are or what your role is. I think this is one of the biggest issues and problems we've got in the sector, is everyone's understanding of each other's role, regardless of whether it's the child protection sector or whatever. So I guess it comes back to the questions that you ask, like, what am I asking this person to do and why am I asking them to do it? Am I providing them with the contextual information they need to make a decision about whether or not they should? And I'm not saying this from a defensive perspective, I'm saying it because I think it's hard, is that you've got service delivery imperatives in terms of your client. We have to make statutory decisions based on a range of factors, and you're one of those factors. And I would say where there's ever any problems, it would really be about referring to our management structure and bringing that to the attention of our management structure and saying, we have this issue. And I know that's a roundabout way of saying, but one of the things we've done in our internal and external sharing policy is ask the question, what are we being asked to do, and what is the person's authority or imprimatur to ask that question of us, so that we're not sharing information willy-nilly, because, and I know that that's not what the context you're talking about, but that we get asked a lot of questions like you would, that we want to know this about the person, or we want you to share this about the person, or we want you to do this for us. So it's about going back to that person and saying, well, who are you, why are you asking it, and what's your authority or what's your mandate? And that's what that ethical framework decision-making I referred to talks about, is what's your mandate? So in terms, it'd have to be examples of, and how we make decisions as guardians, we have to own the fact that we need to explain how we do that decision-making better too. Because the conversation that we have in our teams, and I'm not saying we get this right all the time, is that we have to be able to explain information as we would to a 15-year-old or an adult with an impairment. So if I'm responding and saying, I don't understand it, we've obviously got to work on our communication about explaining context. Does that kind of answer your question? And I mean, specific examples we could talk about in the break, if you want to talk about that. So the question is, how do you achieve voluntary consent under mandatory referrals? I think that's a really good question. I think it depends on the expertise and the skill of the professional involved. I think many people would give really good examples of where there is a mandatory referral, where powerful interventions are achieved based on the quality of the professional practice of the practitioners. Like I've seen really good examples of where there have been mandatory referrals and there's really positive changes. I think it is about being clear about what is my role, what are the parameters of my role, being really clear and revisiting any issues around when I share information. So there may be occasions, and we've had them, where you have to share information about a client because of your mandatory reporting responsibilities or your concerns. I think it is also really good practice would dictate you go back to the person and explain what you did and why you did it.
I think it's also really important to accept as professionals that sometimes our clients, despite what we think is in their best interest, might not agree and they might not consent. And we've certainly had experience with young people where it doesn't quite meet the threshold of a mandatory report, where we would feel much better about reporting it, but it doesn't reach that mandatory threshold. And so we've got to go back and have conversations about explaining why we think we should do this. And if ultimately they don't, we've got to respect that position and say, how can we support them to get to that point in a little bit of time, give them the information that they need to digest it, give them the supports they need to understand that better, but ultimately they might not consent, and we've got to get more comfortable with that.
So the question for the purpose of the recording is around having a non-profit having a child protection policy and taking an approach when they do about sharing information with clients and being accountable to their own clients, but where child safety in this example has a view that they don't want that information shared yet because of, for example, a flight risk. If the person was told about it, they might, disappear. Again, I think you've got to look at your organisational policy and how it intersects with, so in that example, there could be potentially funding agreements that underpin or understand MOUs that underpin your interaction with child safety. I think the right to information and sharing information in the child protection sector is a really vexed issue because of the very issue you raised. One of the common, I know it's not directly answering your point, but one of the issues for us in children and young people's advocacy is that we're constantly, when we ask for information, we're constantly told the information is really upsetting and we can't share that information with the young person because it might upset them. And I think in your example, it might be that there needs to be a difficult conversation with a parent around what's actually going on, and that may lead to, in some examples, I'd imagine more significant intervention by child safety. And if that's the case, the scene setting around that, it's you've got to make your own risk assessment as well, and obviously have, and I know many of you have these conversations, robust, well-documented conversations with child safety around here's what we knew and what we did, and here's how we raised it with child safety, and here was the advice from them, and then here's the decision we took. There's no easy answer because it is a case-by-case basis. And there is, in some examples, the need to be protective about information because of timing, but then it's about asking questions as to why we need to do that and get a bit of context around what are the concerns around that and how much of that can be shared with you. And then, of course, you're placed in the position of, and we get placed in this often as well, how much then you're able to share and at what point, because I think that's a critical point in the sector too, is the timing of sharing information.
I think that it's a conversation that has to be had with child safety, and we need to improve those conversations because it's about being on the same page, that even if we don't agree, that we're working towards the same goal at the end, which might be different for different cases, but we've got to communicate that better between ourselves. I think the right to information is critical for not just our children and young people clients, but their parents and their families equally.
And I mean, just to make a general point about, and you, Lem, you would have significant experience with this, is when government agencies and when people are making decisions, it's what we call in law administrative law. And really when you look at the Child Protection Act, for example, there's really clear provisions, and I'd encourage you to read them if you're doing child protection work, that actually talks about people being informed before a decision is even made. And there are some qualifications around that, which include prejudicing a criminal investigation, for example. But it's not just that you go to defer to, we're not going to tell anyone because this is going to be a difficult issue. And I know that that's not always the case. I know they've also got often some very legitimate concerns, and they've gone through, like you, a process of talking to their managers and working out what to do. But I do think as we share information, because this is what every inquiry always says that we should be doing. It always says three things. We need more training professionally across the board. We need to work collaboratively in terms of our practice, and we need to share information because that's what we need to do. So if we're going to have to do that, the issues around consent and privacy and information sharing are going to be our bread and butter forever. And so, like getting back to the point at the beginning, if 70 to 80% of your work as a manager is supervising and talking to your people about how they're feeling about doing their job, then a good portion of it's going to be also how you're sharing and dealing with information.